Hello, welcome to The Verdict, a podcast by the Carlson law firm. And in this limited series, we go all about car crashes, car collisions, the injuries that happen because of them, and the surrounding topics. And in this episode is going all about auto safety defects. I'm your host, Jeffrey Hinson, and today I'm joined by John Fabry and Brantley White. Thank you for coming on today. So I wanted to cover this topic in an episode because a defective part in a vehicle can cause a crash, which oftentimes or many times can be fatal. And I wanted to give everyone watching this a resource on how to, on what to do in these types of situations. So I want to introduce y'all to my guests here. So Brantley, I want to start with you. Let the listeners, viewers know all about you.
Yeah, Jeffrey, good morning. Thank you for having us. I'm in the Corpus Christi office of the Carlson law firm, and we handle heavy construction accidents, explosions, and defective product cases.
All right. Thank you, Brantley, for being on. Yeah. And John?
Hi, thanks for having me on. I'm based in the Round Rock office of the Carlson law firm, and my practice focuses on mass actions and class actions, any type of a legal issue that happens to affect hundreds or maybe thousands or tens of thousands of people.
All right. Thank you also, John, for being on. And yeah, we'll also be covering sort of the class action side of the defective auto parts also. So stick around. So yeah, I wanted to start this episode with a simple question. And I wanted to start this out with you, Brantley, is what is a vehicle defect and how can a vehicle be defective?
In its simplest terms, a vehicle defect is any condition in the vehicle that renders it or makes it unreasonably dangerous.
Okay. Yeah, because oftentimes people don't really, I think people think about it unconsciously, but then it's not always on the top of their mind. It's like, oh, my vehicle can be defective. It's more of if it happens, then they think about it, then they might stress about it. And as soon as it happens, John, I wanted to kick it to you for this question is that, can someone sue for any defective auto part, or is it only one? And if it is, it's what parts exactly?
I think pretty much any defective part that makes a vehicle, as Brantley said, unreasonably dangerous. In my practice, it's a little bit broader than that. It might not necessarily make the vehicle dangerous, but if you've got a defect in your car, your truck is just sucking gobs of oil, unreasonable amounts, or you've got a transmission that doesn't shift the way it's supposed to, it jerks, it bounces. It might not be the kind of thing that causes an accident necessarily, but it's not operating the way you would expect a normal vehicle to operate.
Okay. Because I would hearing you answer that, because I know based more on top of when it's defective, usually someone can sue when they're injured. Is there certain cases, or does it depend? Is there a case where even if I'm not injured, but there is a defective auto part, is there something there that I can pursue?
In my practice, yes. What you're really looking at is the difference in the value of what you thought you were buying and the vehicle as you actually got it. So the example I gave a minute ago of you buy a car and it just sucks unreasonable amounts of oil. Well, you probably wouldn't have bought that vehicle if you knew that you were going to have to, add a quart or two of oil every time you put gas in it. Or you certainly would have paid a lot less for that vehicle if you bought it anyway. So there's the difference in value between what you paid for and what you actually got.
Okay. And when it comes to these type of cases, Brantley, about how long would a case with the defective auto part take?
It depends on the nature of the defect. There are some pretty notorious defects out there in the history of automotive defects. We're talking about cars that catch on fire when they've been impacted, tires that come apart just after being sold. If it's a defect that's pretty well documented, that the manufacturer accepts, those cases can be resolved pretty quickly. If it's a case that has to be litigated, that is, you have to file a lawsuit and take depositions, that case may take as long as 2 years.
Oh, wow. It is, I want to follow up on that. Is it why, I'm trying to figure out, 2 years, it may seem like a long time in the eyes of the driver itself. Is it because there's a lot of back end stuff going on for them to prove it wasn't defective, or what's the case there?
Yeah, great question. So if we have an individual who comes in and has sustained catastrophic injuries, for instance, somebody who's been paralyzed because of a broken seat back or an airbag that did not deploy, or a seat belt that spooled out and didn't restrain the occupant, the manufacturer may say the forces in the collision were so severe that this accident and these injuries were not preventable. If we have a difference of opinion, we file a lawsuit against the manufacturer. It takes several weeks for the manufacturer to answer that lawsuit. And then the discovery process starts, where we start to investigate the nature of the defect. And that includes getting all the documents regarding the design of the vehicle, taking the depositions of the engineers who worked on the design of the vehicle, hiring our own experts, and potentially doing testing to try to prove the vehicle is defective. So it's a very document intensive and investigation intensive process, and that's why it takes so long.
John, because Brantley had mentioned about 2 years for, depending on the type of cases, would you say it's about the same time duration when it comes to class action or multiple people with a defective auto part?
It, on the short end, can be very similar if you have a manufacturer that recognizes there's a defect issue and is interested in taking care of it and resolving the situation. But if it's going to be litigated, it can actually take even longer because we have all of the same steps that Brantley was talking about in terms of litigation. But for a class action, you also have to have a motion for class certification. It's not automatic. The court has to decide that the case should proceed as a class. And in the event of an eventual settlement, that also needs to be approved by the court. So there's some additional steps. And because the stakes for the manufacturer for settling thousands of claims tend to be a lot higher than just one. For all those reasons, they tend to be more contentious and take longer.
Hey, Brantley, did you want to say something?
Well, sometimes a picture's worth 1,000 words. I don't know if you can see this picture, but this is that's a Suburban that crashed into a vehicle, the side of a vehicle.
Oh, wow.
Can you see that?
Yes.
In this particular accident, you would expect the side airbag to deploy, to go off to protect the driver, correct?
Yeah.
But in this particular instance, the front driver airbag deployed, the front passenger airbag deployed, but the driver's side airbag, the one that should deploy and protect the driver, didn't deploy. So we have the manufacturer's attention right now in that case. We have filed the lawsuit, and I suspect that case will take much less than 2 years because there's some pretty strong evidence that airbag should have gone off. Does that make sense?
Yeah.
And it's evidence within the vehicle, and the strongest evidence is, hey, your front airbags went off in a side collision. Why didn't your side airbag go off? That's a problem. Makes sense, right?
Yeah. And following up on that, because you had mentioned the manufacturer of the airbag, when it comes to the defective auto parts, am I just suing the manufacturers who I'm allowed to sue, or am I allowed to sue like the vehicle maker itself? So say it's like a Ford or a Kia, can I go pursue them instead?
You can sue a component part manufacturer. It oftentimes depends upon the nature of the component and who all was involved in the design. In this particular instance, our belief is that this manufacturer owns this defect entirely. It was originally installed in the vehicle. The manufacturer knew about it. There was a recall on that bag. All arrows point to the manufacturer. So it's kind of a case-by-case analysis.
Okay, and John, would you say that's about the same way when it comes to these class actions?
Yep, absolutely. Case-by-case analysis.
Okay. And then when it comes to these, because I want to ask both y'all this, when it comes to these defective auto parts, as John, we can start with you. Why, and say someone gets into like a crash, a hypothetical crash, why is it important to hold off on repairs after the crash happens or after something happens with the auto part?
Well, Brantley and I probably have a different analysis on this. A lot of the class action type claims are breach of warranty type claims. And under certain laws, depending on how they're pursued and where they're pursued, you actually need to bring the vehicle in and give a manufacturer affiliated dealership the opportunity to repair it. And after making attempts and failing or refusing to repair it, at that point you've got the breach of warranty type action. I think Brantley has some different concerns with preservation of evidence that he could probably speak to.
Yeah, Brantley, would you care to explain why is it important to hold off on repairs when it comes to these defective auto parts?
Yeah, John's right on. So we have a case right now involving a vehicle fire. There was an impact where everybody should have survived because the space inside the vehicle was well preserved. Unfortunately, there was a fire that raged through the vehicle almost instantaneously, and we filed suit against the manufacturer. It's our burden to prove that there's a defect in the vehicle that caused this fast-moving fire. And as John noted, if something happens to the evidence, if a piece of the vehicle goes missing while we have custody of it, then the manufacturer can say, hey, the plaintiffs, the people who brought the lawsuit, destroyed the evidence. So it's very critical that we grab the evidence. It's very critical that we grab the evidence as soon as feasible after the accident, and that we maintain it in such a way that the manufacturer can't make an argument that we destroyed or got rid of the evidence.
Okay. That's interesting because, like, there's always been people come up with these wild, things like, oh, the manufacturers, they want me to come get it so they can destroy all the evidence, or they claim they're going to fix it, but when they're really destroying the evidence. So yeah. So Brantley? Yeah.
Well, let me give you two concrete examples. Okay. Let's say somebody's driving down the road and their tire suffers a D-tread. The tread comes off of the tire and there's a terrible accident. We might want to allege that the tire is defective, but if for some reason the owners of that vehicle destroy the tire or take the tire to the dump thinking they don't need it anymore, it brings up bad memories. All of a sudden, we're in a position where we don't have the evidence necessary to pursue the case. Sometimes not even because of the manufacturer, sometimes a vehicle can go to a salvage yard or a junkyard. The people who were involved in the accident don't realize they need to put a hold on that vehicle to preserve the vehicle, and the salvage yard might take it to the crusher. And then the vehicle defect case that you want to pursue has literally been crushed. It's gone. And so those are two instances where through no fault of the manufacturer, just through poor management of the evidence, the case literally slips through the plaintiff's fingers. So it's really critical that people get on that evidence and preserve it as quickly as possible.
And because you had mentioned throughout, so far as we've been recording, different types of defects that can happen. I want to ask, what's the most, I guess, common defective auto part with that's dependent on injury that you have seen so far in your career?
Well, statistically, there are 4 tires for every automobile. And so that means there are 4 chances for a tire to fail. So I would say in the last 10 years, defective tire litigation has been pretty prevalent. That being said, Jeffrey, there's a whole host of different types of defects, and they can arise with regard to the roof, the seat belt, the fuel system, the airbags. So it's we see a variety of different types of automotive defects.
Okay, and John, I want to bring it to you on this one. When it comes to the cases and the suits, the class action suits that you have dealt with over your career, what has been some more of the common defects that you have dealt with?
I don't have common or recurring defects. It's different every time.
Oh, okay. And okay, I wanted to sort of shift it, because when it comes to these defects, can car insurance play a role when it comes to cases regarding defective auto parts? Brantley?
Typically, when somebody's critically injured, they've suffered disfiguring burns, a family member has been killed. Typically, the car insurance is an important part of the equation, but not an overriding concern. We're talking about people that oftentimes have hundreds and hundreds of thousands of dollars in medical bills. And oftentimes the car insurance of the defendant driver may only be a minimal $30,000 policy. There are exceptions to that rule, but typically when you're talking about a case against an automotive manufacturer, the car insurance is almost a secondary consideration. The first consideration is, let's secure the evidence and let's investigate the defect, if that makes sense. And then we may try to get the plaintiff the car insurance recovery later, but that's typically at the tail end of the case, and for a variety of different reasons.
Okay, all right. And then, John, I wanted to ask you this, because with class action suits, there's usually a lot of people, or a decent amount of people coming forward or being notified to take part. But is there a difference in the case if it's just me and a couple of people versus tons of people?
Yeah, if you or just a few people are impacted, then it's really not suitable for a class action. You would be able to pursue your claims on your own. If you've got hundreds or thousands or maybe tens of thousands of people who are impacted, then it makes a lot more sense as a class action. Because then you can take one or a few people who will act as the representatives for everyone else who's impacted, the class, and pursue it that way. And it makes a lot more sense to get a recovery that way.
Okay. And that, because I'm hearing that when there's like a representative when it comes to these class action lawsuits. So hypothetically, say like I have a defective auto part that's part of this class action lawsuit, how would someone know to essentially take part in it? Am I notified? Do I have to find out a certain way to take part?
The rules for class actions provide for, at different stages, notice to the class. Typically, the class members are not participating. The attorneys and the class representatives litigate the case. And if the court decides that a class should be certified, or if a settlement has been proposed, the court needs to make a determination that it's fair and it's reasonable and adequate for everybody in the class. And at that point, the class would get notice, and they would have the opportunity to come in and they could object to the settlement if they wanted to. That happens. They could also have the opportunity to opt out and say, no, I don't want to participate in this class action. I'm going to pursue my case on my own. So during the litigation phase of a class action, typically you don't see notices going out to members, but before anything's concluded and final, notice would go out to everyone in the class.
So something interesting that as you were just saying, was how someone can opt out of the class action and decide to pursue it sort of way basically solo. I want to get both of your perspectives on this. Why would someone basically opt out and then choose to go solo when it comes to pursuing something like this?
Sure, I'll take that.
Yeah.
Let's say we've got a class action for a defective part, and it's really not going to cover one of Brantley's type clients with catastrophic injuries and hundreds of thousands of dollars in medical bills. That person may say, I would rather pursue this on my own. And I would say that probably makes more sense, because you've got unique injury aspects that are best addressed on an individual basis rather than a class basis. If you're talking about my vehicle consumes lots of oil and it shouldn't, and it's as a result worth about $2,000 or $5,000 less than what I paid for it, and everybody's going to get the same amount of money, that makes more sense on a class-wide basis. That's a kind of situation where it wouldn't make sense to go out on your own to try to get a little bit better recovery, maybe.
And Brantley, throughout your career, have you had clients opt out of class actions and come to you? And what was that like?
I really have to defer to John on the class action matters. I have very little experience involving any aspect of class actions.
Okay. All right.
Really, it's kind of the other way around, Jeffrey.
Yeah.
What typically happens is someone like Brantley will be investigating an individual case and call me up and say, hey, John, this looks like a really widespread problem that might be addressed as a class action. And that doesn't preclude him continuing to represent that person on an individual basis, but there might be a class case for me to pursue. And that's one of the benefits that we have at a very large and diverse firm, is I fairly regularly get calls from other attorneys saying, hey, John, what do you think about this? Does this make sense as a class? And sometimes the answer is yes. A lot of times the answer is no.
Okay. Yeah. John, I want to ask you this. So how would you know what to look for when a person comes to you with a defective auto, and what does that process look like when it comes to proving liability?
What I look for, the internet is a huge help in this, is lots of other people complaining about the exact same problem. The National Highway Traffic Safety Administration has a website where people log complaints, and there are also just pick a manufacturer name, manufacturersucks.com. Somebody will set that up and you'll see a lot of complaints about a particular product. So that's a first level of investigation. And then beyond that, we're back to what Brantley was talking about earlier, where you're digging in on the actual product itself and with expert witnesses to identify a precise defect and the issues it causes.
Brantley, I've heard from a couple other people that when it comes to these defective auto parts and then proving liability, that sometimes experts are hired to figure out certain things with these defective auto parts. Is that true? And then what is that process like?
Well, it is true, and it is a very much a critical part of working on a automotive defect case. And so taking that picture I showed you a while ago involving the airbag that didn't deploy.
Yeah.
So in that particular case, we've had to bring in an accident reconstructionist to talk about how this accident occurred, what the forces of the vehicle were at the time of impact, how fast the vehicles were going. It sounds like pretty common sense stuff, but I can't speak to it as a lawyer. You have to have somebody who's qualified to speak on the subject. You have to have somebody who's an engineer speak on the design of the airbag. You have to have an expert come in and talk about the injuries of the individual and what those future costs are going to be. This particular young man suffered a traumatic brain injury, and he's going to need lifetime care. So we have to have a lifetime care expert create a care plan or a life care plan, a medical doctor speak to what his future needs are going to be. And it's a very involved process. So that's just a sampling of some of the experts that are involved in one case.
Okay. So, because you had mentioned all these experts being helpful when it comes to the process of proving, but what are some of the difficulties when trying to prove that injuries were caused by defects? Like, what is that other side like?
That's a great question. So, again, going back to the example of the airbag that didn't deploy, yeah. Our position is, had the airbag deployed, the occupant's head would have been cushioned by the airbag, yeah, and the injury would not have occurred. The manufacturer will take the position that even if the airbag deploys, the impact is so traumatic and so severe and so violent that the injury is still going to occur. So you actually have to have experts square off on this issue. They're called biomechanics experts that speak on the movement of the body and how much force an occupant's head can withstand without incurring shearing inside the brain. It's a fascinating area of the law and a fascinating area in automotive defect cases.
That's fascinating. Yeah, because I never imagined like so many different types of experts going in trying to prove different angles coming at it when it comes to these collisions. John, I want to ask you, is there something similar when it comes to these class action lawsuits? Is there trying to prove these injuries?
I would say proving damages more generally than, when you think of injury, you tend to think of a physical harm. And the expertise is more in the financial arena. You've got what you paid for the vehicle, and then you've got what the vehicle's worth with the defect, and the differential is your damages and what you're trying to recover.
Okay. And then moving on with these class action lawsuits, for when it comes to these, because sometimes, I guess all of us sometimes will get recall notices for different issues with cars and vehicles. But when the car manufacturer notices something is defective, how soon do they have to send that recall notice out?
That's a good question, and I'm not sure what the requirements are for manufacturer recall notices. Maybe Brantley could help with that one, but that's outside my scope.
Okay. Brantley, do you know how soon a car manufacturer has to send out a recall notice when a part is defective?
Yeah, so that's handled administratively through NHTSA, and NHTSA sets those guidelines. But essentially, as soon as the manufacturer has been put on notice that a safety-related defect exists, they have a statutory period of time to respond. And I want to say it's pretty quick. I mean, by definition, a safety-related automotive defect is one that literally puts the driving public at risk for serious injury or bodily death. So NHTSA, which John noted earlier is the National Highway Traffic Safety Administration, their job, their focus is to protect the driving public from these defects. So they work pretty hard to put pressure on the manufacturer to get notice out quickly. A little subtext or inside story that a lot of people don't know: the manufacturers are oftentimes trying to deflect, trying to avoid a recall being initiated, and they will go to great lengths trying to convince NHTSA that there's no problem with this vehicle. This vehicle doesn't contain a safety-related defect. All these complaints that John was talking about that are being taken to NHTSA, it's amazing, and it reads like a novel. But these manufacturers really stretch themselves oftentimes to avoid that recall.
That's interesting. I'm guessing the answer is simple because they don't want to take the blame because of the recalls. Is that right? Money.
Follow the dollars.
Yeah. Hey, that is true. Money. Yeah. Okay. So.
Yeah, and I didn't mean to make light of that, but if somebody's watching this, when I say follow the dollars, the cost of initiating a recall to a manufacturer and sending out notice to hundreds and hundreds of thousands of people that their car contains a safety-related defect, and that they can take that car to a certified dealer to have the defective part replaced. You can imagine that if a part costs $25 and the service on that part is another $150, and you multiply that by, say, 400,000 people, all of a sudden the manufacturer is looking at a huge bill. So when I say the manufacturer will go to great lengths to avoid the recall, that's why they're doing it. They don't want to incur the recall cost because it's millions and millions and millions and millions of dollars. So they will spend several million on the front end to try and avoid the recall being activated.
See, hearing that is interesting because hearing you say like they would rather avoid spending, millions of dollars sending out these recall notices, but then at the same time, they have that risk of something happening with one of those defects in a case, finishing, and they have to pay out a large sum of money. Why do you think they would rather take that risk?
So years and years ago, I litigated a case against General Motors, and it involved a vehicle called the side saddle pickup truck. And this pickup truck had fuel tanks on the outside of the frame rails that were literally unprotected. The only thing protecting the occupants was a thin piece of sheet metal. So predictably, in side collisions, the pickup trucks would explode into flames. And this happened again and again and again. Finally, NHTSA jumped in and said, "Hey, you've got a problem with these vehicles." Bottom line is, when we started looking at the inside documents, looking at where the bones were buried, so to speak, we found an internal memo, and this is through the help of a lot of lawyers. I didn't find this, but other trial lawyers who were also working on the case found this internal memo called the Ivy memo. And the Ivy memo actually contained a calculation by General Motors on what it would cost to pay out the individual claims of people who had been burned alive in these pickup trucks versus recalling millions and millions of vehicles. So they actually were making a financial decision on how to address this problem rather than addressing the human safety issue, which was most critical. And it was an alarming, it was very enlightening and alarming at the same time on how these manufacturers sometimes look only at the bottom line as opposed to protecting people from foreseeable dangers. And that's a true story.
That's interesting. Yeah, to hear about how it's more about the bottom line than essentially safety of drugs.
All manufacturers, Jeffrey, have gotten smarter because in this age of the internet, if they make a misstep like that, the fallout, like we've seen with VW on how they tried to cheat on the admissions scandal and things of that nature. When a manufacturer gets caught cheating now, it's so well publicized that there's the other side of the coin for them is they don't want to get caught with their hand in the cookie jar, the cheat jar, because then their stock prices fall. So it's an interesting struggle, but for certain, manufacturers still to this day, 2021, are still trying to do everything they can to avoid a recall. That's still true.
Yeah, and I want to ask both of y'all to sort of end it is why are defective auto cases important to society? John, I want to start with you.
In my mind, bringing those cases is what holds manufacturers accountable and leads to eliminating problems and making safer vehicles and keeping people safer on the road. That's it, bottom line.
And Brantley, to you, why are these cases important to society and drivers?
Well, without people pursuing automotive defect claims, oftentimes these defects will go unaddressed. So really, people like John, people like myself, we are truly the watchdogs of the industry. Without us, there's nobody keeping an eye on the auto manufacturers to make sure that defective products are being safely addressed, if that makes sense.
Yeah. And to basically end it, I want to ask both of y'all, John, starting with you, is there anything else you would like to add? Any like notable or interesting class action suits? Is there any interesting stories or comments you would like to add regarding the topic?
As you were talking about recalls with Brantley, it reminded me of a situation years ago, and I was doing an individual case like the ones that Brantley still does today. And there was a catastrophic wreck, a rollover, family members were ejected from the vehicle. And about a month later, when they got home from the hospital, there was a recall notice related to the exact issue that they had, which made it a very strong case. But if the manufacturer maybe had not resisted the recall notice and it had gone out sooner, it might not have happened at all. And that goes to the importance of pursuing these defect cases.
That's interesting. Now, hearing that, it sort of sparked a question. So say something like you had mentioned, like a crash collision does happen and then a recall notice comes afterwards. Is that something someone can pursue, whether that's individual or class action?
They could definitely pursue that case, and we did.
Okay.
And resulted in a good settlement.
Awesome. And Brantley, also to you, is there anything you would like to add? Any, interesting, notable cases, any comments or anything to the topic?
I think I've shared the most interesting comments I have ready today. Thank you.
All right. Well, that's it for this episode of The Verdict. Be sure to keep coming back for the rest of the episodes in this series, all about personal injury with car crashes and the injuries that happen because of them and the surrounding topics. If you're listening to this on podcast platforms, Be sure to rate us 5 stars, the highest rating that you can give us. Yeah, and if you're watching the video version of this, be sure to subscribe to the Carlson Law Firm on YouTube. And if you want to get more detail about the topics presented in today's episode, check the video description. We'll have links to blogs that go more in depth about these topics. Also, we're on social media at the Carlson Law Firm, Facebook, Twitter, Instagram, LinkedIn. We also have a page on Facebook dedicated exclusively in Spanish at Carlson Abogados. Lastly, if you're looking for an attorney, our bilingual team is here to help. We offer free consultations. To look for a location near you, check out carlsonattorneys.com. And you can reach us at 800-359-5690. We take calls 24/7. So until next time, thank you, Brantley. Thank you, John, for joining me on this episode.